Federal officials are responding to a significant cyber attack targeting a sensitive government agency. The Department of Energy has confirmed that Chinese state-sponsored hackers breached the computer network of the U.S. National Nuclear Security Administration, or NNSA, the agency responsible for maintaining the nation's nuclear weapons stockpile. The breach occurred through a previously unknown vulnerability in Microsoft's SharePoint software, a widely used platform for document sharing. A Department of Energy spokesperson stressed that the agency is not aware of any sensitive or classified information having been stolen at this time. Officials also stated that the impact was limited because the department largely uses cloud-based versions of the software, whereas the vulnerability existed in versions that organizations run on their own local networks. Microsoft has identified two China-linked hacking groups known as Linen Typhoon and Violet Typhoon as being behind the global campaign. Security researchers report that the attack has affected at least 400 organizations worldwide. In response to questions, a spokesperson for the Chinese Foreign Ministry said he was not aware of the specifics, but that Beijing opposes all hacking activities. The incident places further scrutiny on Microsoft's cybersecurity practices, coming just a year after a government report criticized the company's handling of a separate Chinese breach of U.S. government emails. Just last week, Microsoft announced it would stop using China-based engineers for some of its Defense Department client support amid espionage concerns. The Department of Justice announced today it is forming a special task force to investigate the origins of the 2016 Russia collusion allegations. The move comes just hours after the Director of National Intelligence, Tulsi Gabbard, declassified a series of documents related to the matter. In a statement, Attorney General Pam Bondi said the department takes any alleged weaponization of the intelligence community with the utmost seriousness, promising to, quote, investigate these troubling disclosures fully and leave no stone unturned to deliver justice. The task force is charged with assessing the newly public evidence and investigating potential legal steps that could follow. Earlier today, DNI Gabbard told reporters at a White House briefing that the declassified materials contain what she called irrefutable evidence that the Obama administration authorized the publication of a false narrative about the Trump campaign colluding with Russia to win the 2016 election. These allegations, which dogged the early years of the Trump presidency, prompted a lengthy special counsel investigation led by Robert Mueller. That investigation ultimately did not find evidence of a criminal conspiracy between the Trump campaign and Russia, though it did detail numerous contacts and Russian efforts to interfere in the election. The new DOJ task force will now re-examine the genesis of those initial intelligence assessments, a development that is certain to reignite one of the most contentious political debates of the last decade. In other news from Washington, the Supreme Court has issued an order allowing President Donald Trump to fire 3 members of the Consumer Product Safety Commission, at least for now. The ruling lifts a temporary block that had been put in place by a lower court. The case concerns the dismissal of Commissioners Mary Boyle, Alexander Hohensarich, and Richard Trumka Jr., all of whom were appointed during the Biden administration. President Trump removed the 3 officials from the 5-member commission back in May. However, U.S. District Judge Matthew Maddox of Maryland quickly blocked the firings, ruling that a federal statute insulates the commission's members from being removed at will by the president. Judge Maddox argued that removing a majority of the board threatened to severely impair the agency's ability to carry out its mandate of ensuring the safety of consumer products. The Trump administration appealed that decision, and today the Supreme Court sided with the administration by vacating the lower court's order. This action is not a final ruling on the constitutional questions at play. Instead, it allows the dismissals to take effect, while litigation over the president's removal authority continues to proceed through the lower courts. Justices Elena Kagan, Sonia Sotomayor, and Ketanji Brown Jackson dissented from the majority's decision to lift the injunction. The case highlights the ongoing legal struggle over the scope of presidential power and the independence of federal agencies. Staying with the courts, a federal appeals court has upheld a nationwide ban on President Trump's executive order aimed at ending birthright citizenship. In a 2-1 decision, a panel on the Ninth U.S. Circuit Court of Appeals affirmed a lower court ruling that found the president's plan unconstitutional. The executive order, a cornerstone of the administration's immigration policy, sought to reinterpret the 14th Amendment to deny automatic citizenship to children born in the United States to non-citizen parents. In its majority opinion, the Ninth Circuit panel wrote, quote, "The district court correctly concluded that the executive order's proposed interpretation, denying citizenship to many persons born in the United States, is unconstitutional. We fully agree," end quote. The ruling leans on a long-standing interpretation of the 14th Amendment's Citizenship Clause, which states that all persons born in the country are citizens. This principle was famously affirmed by the Supreme Court in the 1898 case United States v. Wong Kim Ark. The administration has argued that the clause was never intended to apply to the children of parents who are in the country illegally. Today's ruling from the Ninth Circuit, along with a similar block from a federal judge in New Hampshire, sets the stage for the issue to make a swift return to the Supreme Court for what would be a landmark decision on the meaning of American citizenship. Meanwhile, legal battles over contentious social issues are also playing out at the state level. In Tennessee, a federal judge has partially blocked a 2024 state law that made it a crime for an adult to help a minor obtain an out-of-state abortion without parental consent. The law, known as the Abortion Trafficking of a Minor statute, was challenged by Democratic State Representative Afton Bain and Nashville attorney Rachel Welty. In her ruling, U.S. Circuit Judge Julia Gibbons, who was specially assigned to the case, found that one key part of the law likely violates the First Amendment. Specifically, she blocked the enforcement of the law's recruitment provision, which criminalized giving information to a minor about how to get an abortion or helping them make travel plans. Judge Gibbons wrote that this provision constitutes impermissible viewpoint discrimination because it prohibits speech that encourages a lawful activity, obtaining an abortion in a state where it is legal, while permitting speech that discourages it. However, the judge's ruling was narrow. She did not block other parts of the law, including provisions that criminalize physically transporting a minor across state lines or harboring them for the purpose of an abortion. She also rejected the plaintiff's claim that the law was unconstitutionally vague. The decision comes as many states grapple with the legal fallout from the Supreme Court's decision to overturn Roe v. Wade, which led to a near-total ban on abortion in Tennessee.